Hello, everyone, and welcome. I am so pleased to see so many of you tonight for our symposium on name, image, and likeness, hosted by the Albany Law School Journal of Science and Technology. I want to congratulate Christian Lichtenberger and Amanda Potter and every single student on the journal that has played a role in putting together tonight's fantastic panel. We're really in for a treat, and we're going to learn a lot, and we're going to learn a lot about big business. College athletics is big business. In 2019, college athletic departments reported taking in almost $19 billion in revenue, with little of that money flowing to the student athletes. That changed with the landmark Supreme Court decision in NCAA versus Alston earlier this year. The door is now open for student athletes to profit from their name, image, and likeness. This was a sea change in college sports landscaping, in the college sports landscape, which creates opportunities and challenges for athletes, schools, and businesses involved. States are left scrambling to rethink their NIL laws in this new context, while colleges and universities are figuring out the best ways to support and protect their student athletes, some of whom are adding the challenge of managing their personal brand to their academic and athletic workload. Again, I want to thank the Journal of Science and Technology for assembling a remarkable panel to discuss this timely and relevant topic. And I want to thank every one of our panelists for joining us tonight, taking your time out of your schedules to be with us and to help us understand this whole new world. I'm looking forward to the discussion. And with that, I turn the mic over to our wonderful editor-in-chief, Amanda Potter.
Thank you, Dean Roulette. Hello, everyone. My name is Amanda Potter, and I'm the editor-in-chief of the Albany Law Journal of Science and Technology. I would like to thank you all for joining us this evening for the Albany Law Journal of Science and Technology Symposium on Name, Image, and Likeness in Amateur Sports. We have wonderful panelists joining us tonight, and before we get started, I would just like to thank all of them for being here. I'd like to give a brief history and overview of our journal before we begin. The Albany Law Journal of Science and Technology is a student-run journal that was established in 1990. Each issue covers a vast array of legal issues relating specifically to science and technology. Our members work extremely hard to produce a quality law journal, and I think I speak for everyone on the journal when I say that we are thrilled to have everyone here this evening. Lastly, I would be remiss if I did not take a moment to thank Christian Lichtenberger for planning this event from start to finish. Christian has worked tirelessly to organize and advertise the symposium, and for that we are very grateful. Christian, thank you for your unwavering commitment and dedication to this event. I will now turn it over to Christian to say a few words to kick us off.
Awesome. Thank you so much, Amanda, and good evening, everyone. I'm Christian Lichtenberger, and I'm the symposium editor here at the Albany Law Journal of Science and Technology. Thank you again for joining us. We're incredibly fortunate to have such amazing speakers from around the country who you're going to hear from shortly. Very quickly, I just wanted to thank our journal advisor, Professor Heverly, our editor-in-chief, Amanda Potter, and then Howie in alumni engagement for helping put this all together. It really couldn't have happened without all of them. They've worked tirelessly throughout the process for the past few months. So I really do thank them a lot. So after I kick it over to our brilliant moderator, Dan Lust, I just wanted to give you guys a little bit of the structure that we're going to be working with. So I'm going to kick it over to Dan Lust, who's the moderator. He's going to introduce our keynote, Professor Ferguson. Professor Ferguson's going to give a phenomenal keynote speech. And then following that, our moderator, Dan Lust, will be doing questions to the panelists. So if you have any questions at all for any of the panelists in particular, please try and save them till the end, to the last 15 minutes. So at 7:30 p.m., start putting your questions in, and at 7:45 p.m., we'll start answering them for the last 15 minutes until we conclude at 8 p.m. So now, before we can finally get into the program, our moderator, Dan Lust, is one of the most prominent sports and entertainment law attorneys that we have out there. He's been incredibly influential to me as a law student, with conduct detrimental, as well as all of his work that he's done with law students across the country. He's helped them get placements with opportunities they wouldn't have otherwise. He also is an adjunct professor at New York Law School, where he teaches sports and entertainment law. He's helped create a group I'm a part of, the Student Sports Network, that has been incredibly influential throughout, and it's helped a lot of students, as I've said. Now, without further ado, I'll kick it over to the man himself, Mr. Dan Lust.
Thank you, Christian, for that lovely introduction. I guess I should mention, you didn't mention it, but I went to Union College, which is about 15 minutes down the road from Albany Law School. So I have plenty of friends that went to Albany and know the Capital Region incredibly well. So without further ado, I know we're on a little bit of a time crunch, and we'll try to stick to the schedule as best as we can. So yeah, as Christian laid out, we have a tremendous panel tonight, obviously kicked off by Professor Kenneth Ferguson. I'll provide his intro, and then we'll let Professor Ferguson go as long as he wants. We're very fortunate to have him, and then we'll get into the panel. So without further ado, Professor Kenneth Ferguson is a professor of law at the University of Missouri, Kansas City School of Law. He earned his Bachelor of Arts from Drake University and his JD from O.W. Coburn Law School, Oral Roberts University. Professor Ferguson is recognized nationally for his bankruptcy law and sports law scholarship. His bankruptcy law scholarship has evolved from preferential transfers and applying linguistic theory to bankruptcy law, to proposing an innovative two-part business in fact and business in law analytical process that courts should consider in determining whether a debtor can avoid the reorganization process of Chapter 11 bankruptcy by instead selling their business under Bankruptcy Code Section 363. Ferguson's sports law scholarship considers application of assumption of the risk theory to distinguish liability for injuries to athletes in amateur and professional sports. His sports law scholarship also focuses on achieving gender equity under Title IX for girls from economically disadvantaged rural, urban, and minority communities. So with that said, Professor Ferguson, I will turn the mic over to you, both metaphorically and physically. If I had a mic, I would hand it to you, but by all means, take it from here. I think you're on mute, Professor Ferguson. Do you hear?
Let's fix that.
All good, all good.
Well, I'm always impressed with what people say about me, because I very seldom read my bio. But I wanted to start today by I'm not going to take a whole lot of time, because there are a lot of other people on this panel that are a lot more experienced and maybe even more knowledgeable in some areas than I am. But I wanted to start off by saying, I'm going to start off the talk by talking a little bit about the two cases that got us where we are today, the Bannon case and the Alston case, which was recently decided by the Supreme Court. And I'm doing those cases just really as sort of a backdrop to talk a little bit about the NC2A before moving on to summarize some data about name and likeness statutes that have been enacted throughout the country. And then I'll briefly talk a little bit about these name and image and likeness statutes and Title IX before finishing up with just a brief statement about race and who profits literally from amateur sports, or at least the notion of amateurism that the NC2A has been pushing for some time. Historically, the NC2A has taken the position that the critical role it plays in maintaining what it refers to as this revered tradition of amateurism in college sports, it makes the argument both in the O'Bannon case and then also in the Alston case, that any challenge to its amateurism rules must fail as a matter of law because the Supreme Court, and it makes reference to 1984 Supreme Court decision NC2A versus the Board of Regents. It says that that court has held that these rules are, meaning its compensation rules, are presumptively valid. Of course, the Ninth Circuit in Bannon disagreed because the court said the language that was relied on by the NC2A to make that argument was really dicta from the Supreme Court case that it cited. The Bannon case also rejected a second argument made by the NC2A. In that case, the plaintiff claimed that the NC2A's eligibility rules forbidding student athletes from being paid for the use of their image, name, image, and likeness violated antitrust law. The NC2A contended that its compensation rules were not subject to antitrust law because the compensation rules were mere eligibility rules which do not regulate commercial activity. And we've already mentioned the commercial nature of amateur sports here in the US. Although the restraint had no effect on commerce, I'm sorry, any restraint that has no effect on commerce is really exempt from antitrust law. The Ninth Circuit, however, rejected the NC2A's argument that its compensation rules had no such commercial effect. According to the court, the modern definition of commerce is broad enough to embrace a transaction in which an athletic recruit exchanges his labor or her labor and their NIL rights for a scholarship at a Division I school, because it is undeniable that both parties to that exchange anticipate economic gain. The court ruled that the NC2A's compensation rules were therefore within the ambit of the Sherman Act. However, the Ninth Circuit rejected part of the plaintiff's claim, concluding that the district court clearly erred in its viable alternative to allowing student athletes to receive NIL cash payments untethered to their educational expenses. Now, the NC2A again in NC2A, Alston versus NC2A, as it did in O'Bannon, it argued that its restrictive compensation rules were presumptively valid, and that the Supreme Court precedent, again citing Board of Education versus Board of Regents, I'm sorry, expressly approved its limits on student athletes' compensation, and that approval forecloses any meaningful review of those limits by the court. And I thought that was a pretty bold statement to make. The court obviously rejected the applicability of Brown of the Board of Regents and determined that its review under the rule of reason approach was really more deferential to the NC2A than the NC2A actually was representing, and that the quick look analysis of Board of Regents was applied to condemn the NC2A's restrictions. So that sort of set us up for the name and likeness legislations that have been passed and that are continuing to be proposed in states throughout our country. The National College Players Association, NCPA, has developed a grading system for assessing state laws, which provide student athletes the utmost freedom to negotiate for monetizing their name, image, and likeness. The grading scale is from 0 to 100%, with the higher percentages scores going to states with laws that provide the greatest authority for student athletes to make NIL deals. The National College Players Association has rated states' name and likeness laws, and they rely on about 21 benchmarks in assessing those laws. Now, I'll just point out a couple of those benchmarks. For example, they assess whether the laws give student athletes freedom to receive food, shelter, medical expenses, insurance from third parties. They assess whether the laws prohibiting athletic program boosters and booster clubs from paying student athletes for their name and likeness. That such a law would in fact be contrary to the recommendations that were made by the NC2A regarding how involved should universities be in the payment of name and likeness compensation to their student athletes. They assess whether laws allowing colleges to prevent student athletes from what they refer to as pre-scheduled name and likeness deal activities, tweeting during the games. They also look at whether those laws allow colleges to dictate whether students could wear at non-mandatory college events the logos, the marks of their sponsors. Those are just some of the things that were mentioned as possible factors to be considered. Now, it's pretty obvious from the factors that I just mentioned and others that I did not mention, that there will be a recruiting advantage to the benefit of colleges and universities that are located in states with higher benchmark percentages scores for those scores that are given by this organization. And it really points out that unless there's also some type of federal approach to the name and likeness laws, there will be a continuing problem in the NIL space for students or student athletes in states with low rating. Okay, and this is sort of the flip side of the recruiting balance, because if you go to school in the state with a high rating, it means that your benefits would be greater. The highest ranked school of the 28 that have enacted statutes, and that number may have increased since this work was done, was New Mexico State with a score of 90%. Maryland is 81. Missouri is 81. So is Oregon. So and the lowest score was Georgia. No, I'm sorry, was Illinois with a 43%. Now, there schools or states that have not enacted NIL laws received a mark of 0, so that there's approximately 22 states that have not enacted any of those statutes as of yet. Now, The one question raised among others, and many of our other speakers will raise some of those other issues. The one question that looms large in the face of new name and likeness legislation that has been proposed or that have been in fact enacted is, will these statutes lead colleges and universities to violate Title IX? Some, of course, answer that question in a resounding yes, while others answer the question with just the opposite affirmation. The California statute, referred to as Fair Pay to Play Act was enacted and signed into law by Governor Newsom in 2019. And this law makes it unlawful for the NC2A, any other athletic organization, and colleges and universities to limit the rights of student athletes to receive payment for the use of their name, image, and likeness. The legislation, as I'm assuming most of those legislations that have been enacted or will be enacted, sought to correct the exploitation of student athletes which have occurred in collegiate athletics. Since enactment, many other states, of course, have enacted legislation. Now, the act places no limits. Now, other name and likeness legislation will place limits on compensation which student athletes may receive. Some states prohibit the institution from actually paying student athletes for their name and likeness, name, image, and likeness income. And many of the statutes that were assessed also included factors that enabled institutions to, in fact, put in place someone who guides, helps, assesses whether student athletes' name, image, and likeness contracts are, in fact, reasonable, fair, and so forth. So they provide some services in that way. Now, it's clear, I'm saying it's clear, but since most of athletic income, at least in the Power 5 schools, come from those conferences, come from two sports, FBS football and men's basketball. The assumption is that Title IX now would in fact be violated because of this sort of built-in structural benefit that goes to men's student athletes. Now, Title IX, of course, was enacted in 1972. And if you look at the growth of female student athletes involvement in sports since the enactment, it has been incredible. Now, the relationship of the regulations that were issued by the U.S. Department of Health and Education as part of the law provided three broad categories of compliance regimens: athletic scholarships, benefits and services, effective accommodation of student athletes or student interests and abilities. Now, scholarship obviously required that scholarships be applied substantially proportionately to all students, regardless of gender status. If there's any disparity, the disparity must be shown to be the result of some legitimate non-discriminatory factor. The other factor that's considered in whether an institution is in violation of Title IX is referred to as benefits and services. As long as there's an equal opportunity in all aspects of both men and women programs, institutions are permitted to offer separate athletic programs for men and women. The regulation listed about 10 non-exclusive factors which are to be considered in determining whether equal opportunity exists. I won't read all of those, but here are some examples. Whether the selection of sports and the level of competition effectively accommodates the interests of and abilities of both sexes, whether there's provision for equipment and supplies that are equal or comparable, travel and per diem allowances, provision for locker rooms, practices, and competition facilities. All those factors must be provide equal benefits to both sexes. Now, there was later added one factors in addition to publicity, recruiting and support services, and this support services is one of the factors that will sort of come in helping us determine whether or not an institution can implement the name, image, and likeness statutes and still prevent them from violating Title IX. And here's what many of these statutes, for example, will have an officer who reviews the contracts that come in, although they may not pay student athletes, but they review those contracts and then obviously provide the reviewing services to those student athletes. Now, if those services are being provided equally to the men and women student athletes, then obviously there will not be any Title IX issues. There's a potential for Title IX violation if the third party who is in fact providing these name and image deals, if they are favoring male versus female students. And it's in that light where an institution can be implicated for having violated Title IX because the third party is coming through the institution, and there's been court decisions that have imposed Title IX violations when on institutions when, in fact, some third party is providing services. So essentially, the third party may be considered an agent of the institution, in which case, if they're violating Title IX by how they perform their services, then in fact, the university will. And so universities have to be very careful in monitoring the contracts, the services that are provided, and partly because the institution, because of the history of dealing with Title IX issues, are probably more experienced at being able to identify when there's potential problems. Now, I'm going to finish with talking a little bit about who profits from amateurism. A study of athletic departments financing was conducted and reported in an article to the National Bureau of Economic Research. The article was titled, "Who Profits from Amateurism? The Rent Sharing of Modern College Sports." According to the study, 58% of the total athletic department's income of NC2A Division I football subdivision schools is generated by two sports, men's football and men's basketball. And I think a lot of times when people quote those statistics, they lump all Division I schools within those numbers. Okay, but that would not be an accurate thing to do. 15% of the total athletic department's income comes from other sports. The other 27% of the total income comes from media rights sales and other resources. Now, barring student athletes from sharing in the profits these institutions generate has created a momentous economic rents for universities that are in the Power 5 athletic conferences. The data studied included income generated by all Division I sports. The data measured the cities and towns that student athletes came from, the colleges, came to the college and universities from, the high schools from which those student athletes graduated, their family income, social economic background. The data revealed that revenue production of athletics departments at the university where student athletes attend, including how much the athletic department, how much the central administration of the university contributes to the budget of an athletic department. And what, having looked at all Division I schools, the statistics and the algorithm broke those schools into two groups, okay? Those that were profitable and those that were not. The schools that were profitable, meaning that they were self-sufficient, they were not getting financial support from their central administration. Those schools were all from the Power 5 conference. And so when people talk about how much money institutions are making, you have to make a distinction. And I think the Supreme Court did in both those cases that I mentioned, made that distinction between schools from institutions that are in the FBS football and men's basketball, okay? Now, it came as no surprise that that predominantly Black and student athletes from other racial minorities within the Power 5 conferences subsidize all other campus sports. This data confirms what Justice Kavanaugh what his critique was in Alston. According to Kavanaugh, the bottom line is that the NC2A and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars in revenue for colleges every year. Those enormous sums of money flow to seemingly everyone except the student athletes. College presidents, athletic directors, coaches, conference commissioners, and NC2A executive take in 6 or 7 figure salaries. Colleges, Justice Kavanaugh continues, build lavish new facilities, but the student athletes who generate the revenue, many of whom are African Americans and from lower income backgrounds, end up with little or nothing. Everyone agrees that the NC2A can require student athletes to be enrolled students at a university in good and in good standing. But the NC2A's business model of using unpaid student athletes to generate billions of dollars in revenue for the colleges and raises serious questions on the antitrust law. And I think that statement by Kavanaugh was really a signal. In particular, it is highly questionable, the justice goes on to say, whether the NC2A and its member colleges can justify not paying student athletes a fair share of the revenue on the circular theory that defining characteristics of college sports is that colleges do not pay student athletes. And if that asserted justification is unavailing, it is not clear how the NC2A can legally defend its remaining compensation rules. And so that concurrent opinion signals that there may be problems for the NC2A and the NC2A's model for amateur sports in the future. And with that, I will end my comments.
Thank you, Professor Ferguson. That was, obviously when it comes to NIL and Alston, there's so many levels to it. So, but I'm happy to continue that conversation onto the panel. Professor Ferguson, any further thoughts? I guess anything further on your end before we head into the panel?
No, I think I'm excited to hear from the other panelists.
Well, we appreciate your time and obviously those lovely words. We have we have a rock star panel that Christian put together today following Professor Ferguson's comments, all about name, image, and likeness from college sports to high school, and obviously, how these type of deals impact the professional ranks as well. So the itinerary that we have, I think people will be happy with it. I know we have some people in the audience on the agency side that are listening to this, so certainly tracking the right type of attention. A little bit about myself before we jump in. As Chris mentioned in that lovely introduction, I run a podcast called Conduct Detrimental. We talk about all things sports and law. And for, I want to say, we'll say 60 days leading up to July 1st, there was absolute pandemonium. And we all circled it. I'm sure all the panelists knew it as well, that on July 1st, it would be the wild, wild west. I think we all, to some extent, thought the NCAA was going to be a little bit more involved. And as Professor Ferguson laid out, NCAA really hasn't been in charge of this, and you have different states with different models, different rules. So certainly the lawyers and the professors have a little bit more of a heavy lift when trying to decipher NIL rules and impacts across state lines. So we are now just about, now my math is probably off, but I think we're just over 100 days into the NIL era. So I think it's a good time to take stock and talk about where the states are doing it differently, maybe what's on the horizon, and kind of where we go from here. So let's start off with my friend, Professor Anita Moorman. She's a professor in sports administration at the University of Louisville. I know Professor Moorman from her Twitter persona, but I'm sure most of you know her from her academic credentials. Just briefly about Professor Moorman. Professor Moorman is the professor of sports administration at the University of Louisville. She teaches sports law and legal aspects of sport. She's licensed to practice in the state of Oklahoma and was admitted to practice before the United States Supreme Court, when she served as co-counsel for 9 disability sports organizations on an amicus curiae brief in the landmark Americans with Disability Act case involving the professional golfer Casey Martin, and that was the case Martin versus PGA Tour in 2001. She served as an expert consultant for the SB 206 California Community College Name, Image, and Likeness Working Group, studying the impact of NIL policies and legislation on community college athletes. I'm sure we're going to be hearing about that today. Professor Moorman's research and scholarship interests focus primarily on contractual relationships in sport and policy development surrounding amateur athletes' rights. She's the editor/co-author of a leading textbook, Sports Law: A Managerial Approach, 4th edition. I might need to pick your brain, Professor Moorman, off this about a new textbook for my class. So it's very good to know that. Okay, moving down the line, and then I'll open it up for questions. Dave Meluni is an assistant teaching professor at Syracuse University. Professor Meluni joined the sports management faculty at Syracuse University full-time in 2018 after 4 years as an adjunct professor in the department. Professor Meluni has over 20 years of experience in the sports industry, including 2 years as Vice President of Sales and Business Development for both 805 Stats and Infinity Sports and Entertainment. He spent 5 years as the Vice President of Sales at Sidearm Sports, where he negotiated and signed agreements with the University of Texas, Kansas, the Heisman Trophy, and the Maui Invitational, as well as hundreds of Division I, II, and III institutions. Okay, moving on. Rayleigh Keller is an NIL specialist at Opendorse. I also know Rayleigh from his social media, which I guess is a totally normal thing to know someone from. Pleasure to meet you in real life, I guess, this kind of real life. Rayleigh is the NIL specialist at Opendorse. In this capacity, Keller leads in the creation, development, and sale of Opendorse's NIL policy kit and Opendorse's compliance solution, Opendorse Monitor. Additionally, as a graduate assistant, Keller serves as the NIL coordinator for the University of Nebraska-Lincoln, where he currently provides student athletes with education and guidance on all topics NIL. Prior to Nebraska, Keller also served as a student athlete representative on the NCAA's Division III NIL Oversight Committee. And last but not least, we will turn to Professor Kenneth Lewis, who's over at the Shepherd Broad College of Law. So since 2009, Professor Lewis has excelled at the Shepherd Broad College of Law as a tenured professor. Along with his success teaching, Professor Lewis has found success as the founder, proprietor, and chief counsel of Kenneth L. Lewis, PA. In his private practice, Professor Lewis specializes in commercial litigation, condominium law, and sports and entertainment. Moreover, he has represented celebrities and professional athletes in addition to negotiating contracts between teams and players. Furthermore, he has drafted transfer and loan agreements between sports teams and presided over groundbreaking enterprise disputes. Professor Lewis has appeared many times on television and radio, and he is sought for his legal expertise in sports law and other matters. Professor Lewis is also the founder and chairman of Legal Capital, an organization that provides loans to lawyers and lawsuits. He's a partner in Ballers Not Ballers Apparel, and he is the founder of Lawyer Life magazine. He's also host of the Kenneth Lewis Show, which airs on YouTube. Man, I'm going to give my reading comprehension there like an A+. That was a lot to read, but reading is fun. This is why we go to school, guys. Okay, so let me start before we get into the questions. Professor Moorman, let me turn it over to you. We'll just go each of the panelists just very briefly. I want to keep our these comments pretty short, but I want people to kind of get an overview of where everyone is, and then we have a list of questions, obviously that I have for you guys. So Professor Moorman, if you can give us your elevator pitch on the world of NIL, 100 days in.
Yeah, great, Dan. Thanks for the intro. It's very nice. And thank you, Christian, for the invitation. I appreciate being here. 100 days in, I think mostly what we're finally beginning to get is some data. And data is going to help inform where we go next. We see an uptick in activity. It is still the wild, wild west, as you say. And I think we're starting to see some cyclical and seasonal activity in terms of announcements and activity that ramps up as the season begins to start. So now we're seeing a bunch of basketball deals before we saw football deals. So I think that should be a normal expectation. Next summer, we'll probably see an uptick in camps. So I think we're going to need a year at least to really start getting a good idea from where we are. But I think 100 days in, We see that athletes are really active in the social media category, and that was predicted initially, and we have a lot of good research already that gave us some pretty good predictions of how that may play out, and a lot of that is being verified. So I'll leave it there in terms of not getting too much into the weeds yet, but I think right now there aren't a lot of surprises in the types of deals athletes are doing. I think it's still that we just really don't know how much more is going to happen and what this is going to look like a year from now.
Well, I think that's well said. I know there was some literature that came out maybe in the last 48 hours that I think the average deal that it's being signed by a college athlete across the country is worth about $5,300. So, I think that's maybe expected in some sense, but there obviously are some high six-figure, seven-figure deals. But by and large, right, you're looking at a lower number for the average deal.
Yeah,
Professor
I think
Meluni,
I thought the average was around 1,100. There were like 5,300 actual deals so far, at least with this one verification partner. And then the median was around $63. So I think that median number is really a better reflection of where the market is. But I'm not the economist, so I will definitely defer to the sport economists and the accountants on here on that end of it. Thanks, Dan.
Yeah. No. Either way, I think either number, and I'm going to defer to you. Because I'm doing a lot of reading here. You just have to, when you're called on, I'm doing all the reading. I think either way you look at it, the numbers are, I think, a little bit lower than expected. But you know what? It's obviously the first 100 days. It's not we're supposed to get there right away. Professor Meluni, let me turn it over to you. Just overall observations 100 days
Sure.
in, I'll give you the floor.
Yeah, I mean, Anita's right. It's over 5,000 transaction, about $1,300 per transaction, and about the shoes right on with the $63, the median transaction. But in my world, because I'm a marketer and multimedia rights side person and teaching a course here at Syracuse, the Wild Wild West is, I think something we're going to hear all night long. And from my side of things, it's the social media, it's the engagement. We're probably going to get a little bit more into the Spencer Rattlers of the world and performance-based, and we're seeing that in the NFL. Look last night where, Cam Newton comes back and I'm back. Well, his advertisers didn't go anywhere. So there's so many other folks on here and things that I want to talk about, but I think we have to be cognizant of the licensing departments because what's going on with the use of the marks, I think that's very interesting. The JMIs and the Learfields of the world, they're paying astronomical dollars for the multimedia rights. If you look at Carolina next year, they're on the hook at Learfield for $11 million. And now you're going to have a student athlete that potentially could be out there, conflicting with a Ford deal. And can I use the marks? Can I not use the marks? So, but that's kind of where I'm at. And I know really I'm very fond of everything that Opendorse is doing. And in my opinion, Nebraska is the best school in the nation doing this. And there's no coincidence that that's where the Opendorse folks are at. So I'm sure you're going to turn it over to him, but that's correct. Kind of where I'll stay right now.
That was a good guess because I'm going in order of the introduction. So yes, that's where I am going next. So Rayleigh, and I no objections here. I think Nebraska has something very special going on. Their fans are obviously among the most passionate in the country, and of all these states that were popping up with NIL laws, 90% pre-July 1st were in the SEC, and then you had New Mexico, which was kind of an outlier, and then you had Nebraska. So and maybe Ohio too, but those are really a handful of states that had NIL laws prior to July 1st. So Nebraska certainly was at the forefront of that. So Rayleigh, let me turn it over to you. Tell us about what you guys seen, you and Blake Lawrence over at Opendorse in these first 100 days and kind of where we go, just at a very high level.
Yeah, absolutely. Well, David, Dan, I feel like you guys ought to join the 90,000 fans here at a home game here in a couple of weeks. You guys are big supporters, so I appreciate that. But what
just don't lose in the fourth quarter again. That's all I ask for.
No comment there. What I will say, I guess, 100 days in, elevator pitch, I would say that pandemonium that you were describing, Dan, leading up to July 1st was a real feeling. There was a big rush, especially the first few weeks. And then it started to feel like things normalized a little bit. They settled down. But for me, I think there's a point in every day when I come across an NIL deal, I'm scrolling on Twitter or something like that, and I think to myself, wow, this is incredible. Take yourself back 6 months, take yourself back 25 years when the Huskers were getting it done on the field, right? There are times in collegiate athletics history when this is hard to even comprehend that this would be legal. So I think that's impressive. And the student athletes who have really been taking this to another level with apparels, in a variety of different social media deals, I think that's impressive. And now that's 4 months in. So let's take this 4 years from now and start thinking about what opportunities are going to be there. How are student athletes going to establish themselves for true business ventures down the road? So that's kind of where my mind's at. And I'm excited to see where this continues to grow.
Well said. And Professor Lewis, you can take us home. Again, your high level thoughts 100 days in, where we've been and where we go from here.
Well, I concur with Professor Moorman. I don't think there have been many surprises in terms of the way things have gone. What I will say, however, is that there's some uncertainty about what will eventually happen and where we will stand. I will tell you that there's some other impacts that were probably unanticipated. So you have student athletes right now who are not just consulting with agents or with attorneys so they understand the lay of the land, but they're consulting with other professionals, recognizing that the athlete is him or herself, the brand. And so they're trying to learn brand building, et cetera. NIL has also impacted some of the grassroots organizations and the organizations who work with foreign students and students who are from statistically underrepresented groups. Because, for example, one of the things that you'll see with some of the grassroots organizations with NIL is what happens when international students are brought over. Can they take advantage of these kind of NIL deals on F1 visas? They're international students. Are there tax implications? Are there social security implications? Can they actually work? And so that has stretched into those organizations, and the athletic departments themselves are now rushing to deal with and understand some of these other tangential issues. But I agree with Professor Moorman, not a lot of surprises thus far.
Okay, so I've made two notes of those. Professor Lewis, the international issue, and Professor Meluni, the issue with respect to athletes being benched and potentially losing some deals. I think those are two really kind of hot button issues, at least for the sports fans. I think that is particularly important. Okay, but that said, so we have 4 panelists. I've done, as Chris knows, I moderate a lot of panels. I want this to try to be as conversational as we can, but I'm going to open questions up to the floor. People can respond in turn. You guys all have your individual specialties, but you're all on here because of your NIL background. So I'm just going to, I'll lead off with the first one. Feel free to jump in. And if people want to interrupt, it's okay. I'll be the ref. I'll make sure people are playing nice, but by all means, the conversation's better if people are engaging and not just I talk, you talk, you talk. I think it's much better that way. Okay, so first and foremost, again, I'll open this up to the panel. Just generally, can someone discuss the monetization opportunities for student athletes, particularly those that play less publicized sports or divisions? So, for example, I know when the NIL movement started, there was a Division III tennis player that had kind of this viral video of him being really funny. I think that's kind of important, right? As much as people want to be NIL agents and work in the space, everyone's going to go after the Spencer Rattlers of the world. But there's an issue, right? If you are any less in one of those non-revenue generating sports at a Division II, Division III level, what opportunities are out there? I think I'll open that up to the panel, whoever wants to take it.
I mean, I don't mind starting because I'm seeing it a little bit here. I met with a student athlete today that's going to go back to Texas during break, female athlete, and she's putting together a camp, right? She's got a very good friend at another institution. They're going to do a camp together, and those are ways, Dan, right away to make a little bit extra money. Now, understanding insurance and the facility and all those other things, but doing lessons. I mean, I think that's something that right away that we're seeing. Anita had mentioned it with all the transactions and camps and stuff are really kind of down low. On that list, I think it was like 4%, but that's because the students were coming back. So I'm very interested to see who's going to take take advantage of that. Here at Syracuse, we have a week for Thanksgiving. Other schools might not have that. But then when you go back for a month, I'm in it right now. I mean, I have two boys, 16, 12, and they're knee deep in hockey and baseball. And I just know the money that flies around for, a half an hour hitting lesson or skating, and who's not better than an expert than a student athlete that a parent is going to want to send their potential, athlete to a lacrosse player, female lacrosse player, whatever it may be.
Yeah, I'll hop in on this one too. And Dan, I'm glad you brought up Division III. So that's Jake Bren. He's from Simpson College, which is they're American Rivers Conference school. So they were a rival of my undergrad, Nebraska Wesleyan. But I was excited to see that, and where my background comes from the NIL side of things is being the Division III student athlete advocate for these opportunities. And something that I firmly believe is that there are opportunities out there for every athlete, no matter what sport, no matter what division, no matter where you're at. And I think a big piece of it is how proactive the athletes are being. So Dave, your example of your student athlete going and organizing camp, that's something where the student athlete had to spearhead the effort themselves. And it's not necessarily a national brand reaching out to them. Like a lot of student athletes probably have this misconception that they're going to be inundated with deals from, the degrees of the world and national brands. But I think having that mindset that a student athlete can go out and make opportunities for themselves is important. And one other thing I wanted to bring up too is I'm a big numbers guy, and from Opendorse's data over the last 4 months is that what we have seen is not really a surprise, is that the compensation dollar, so the actual dollar amount, has largely been dominated by football and men's and women's basketball. So that's 87% of the dollars for NIL deals have gone to those sports. Now, what I think is important to bring up though, is that 53% of the activities have gone to all other sports. So while a large amount of the dollars themselves have gone to those more popular sports, I think a lot of the activities are being diversified across different sports and divisions.
Yeah, and I'll kind of jump in on the community college side just to share. We did some social media evaluations for the community college context in California. And so we're talking 24,000 athletes in that California system, and found that at least 5% of them had monetizable social media profiles that meant crossing that 5,000 followers threshold. And it was not in your footballs and your basketballs. I mean, it was for women, for female athletes, beach volleyball, track and field, swim and dive, softball, golf were all represented in that group. For the male athletes, certainly football and baseball were there, but so were golf and soccer and track and field. So on the social media side of these opportunities, I think there's tremendous parity across sport, across division, and across gender.
Yeah, I'll add that Rayleigh is in fact right, that there are opportunities for everyone, no matter what division. Now, the fact that there are opportunities for everyone doesn't mean that the opportunities are identical. Doesn't mean that they're equal, right? It varies in the market, and it also varies in the sport. And quite frankly, we're also seeing that it may vary for members of the same team. But notwithstanding all the high profile deals, there are a lot of local and regional opportunities with local and regional businesses who want to partner with athletes who are popular, who are well known in particular neighborhoods or in regions. And it's interesting that Professor Meluni talked about the camps. One of the questions that I received from a soccer player is, I want to do these camps. And, he's a very well-known, well-regarded soccer player. And my buddies and I were thinking of doing these camps for kids, etc. But what if my college coach has camps? What if he does his camps in the summer? Would I run afoul of my own coach if I had a camp? Would that be viewed as competing? So yes, there are opportunities, but still there are some logistical things to address and some questions to answer.
Okay, so I think, obviously all good points. I think maybe we're our next frontier, obviously, in sports, people are kind of looking right at a certain point, right? NIL agents and I have a lot of people reach out to me how I can get in touch with, student athletes and how I make I actually, you can't even say student athletes anymore. Well, I guess we'll get into that, but that's now an NLRB says you can't say student athletes, which let's say college athletes. But I think, the next frontier, obviously for agents, right, is going to the high school level, right? People are going to continue to try to, dig to that next level and try to get some type of advantage. So obviously on a statewide level, it's not a national bill that we have yet, but state by state, by and large, there is, I think about half the states have a bill in the books that allows NIL to occur. Some are effective, some are not. But that said, right, it doesn't really matter if your state has a law or if it doesn't have one, because the NCAA says you can, have NIL deals and you're not impact your eligibility. Kind of the opposite of that, we don't have as much clearance, and we obviously don't have one unifying high school body that looks at, that functions similar to the NCAA. So it's very much in a state by state basis. So again, I'll kind of expand it, or I'll kind of just give it to the floor. From July 1st till today, we've obviously seen some movement on the state level with respect to high school athletes being allowed to profit and enter NIL type deals while retaining their eligibility. I'm going to open up to the floor. What are we seeing on that front? Any type of observations, any type of trends we're seeing?
I mean, I can jump in because New York just agreed to this October 20th. And I know Braley's on Twitter on this stuff, but if I understand, it's California, New York, Illinois, Nebraska, and New Jersey have it up right now. And I'm not sure about Idaho. That might be the one. But, the interesting
also. Right?
Who was it, Kenneth?
I think Maine is going that direction too, right?
Oh, yeah. So I can't, every minute it changes, right? But from a New York standpoint, it's interesting that the high school association has come down with this. And I actually met with our section here in Syracuse recently, and they're not freaking out. They're more concerned for the parents, right? Because now listen, parents are nuts. Like, I was at a hockey tournament this weekend and I saw coaches, players, and parents get thrown out. And I'm not kidding, they're 12 years old. So from that standpoint, everybody's looking, how do I monetize? How do I monetize? How do I recoup maybe thousands of dollars in travel and all these other things? But from a New York perspective, which was interesting, and some people have asked me why, there's no opportunity for the use of the school marks, the name, the section of the state. Well, here's why. I will tell you this. Our high school is a AA, right? So the highest you can be is AA. We don't even have a licensing department. We have one athletic director. There's no way that Mike's going to be able to control all of that that's going on. So that's the understandable side. And I actually give kudos to New York State for where they've gone with this. But to be honest with you, our local pizza shop, we're the West Tennessee Wildcats, and our local pizza shop is called the Wildcat. I went in there the other day and I said, Dan, why don't you just, do something with maybe food? And then the other thing that he kind of lost the opportunity was the National Letter of Intent Day, right? He's got a restaurant that he could have invited these athletes, given them $50 gift cards posted on all their social. All the athletes I looked at, and Anita hit this right on the nail on the head. Every one of those athletes that have signed Division I or II, there were 6 female and 2 male. They're all at about 1,500 social media. So, if we're aspiring to get to that 5,000 mark, and then the engagement, that's where we're looking at with these athletes is you got to get the followers, but every time you post, there's got to be this engagement. It can't be 2%. Sean Tucker here at Syracuse has only got 5,000, but his engagement rate is like 70 to 80%. So that's the key here with all this stuff, in my opinion.
Different Dan. I own a different Wildcat restaurant. It's actually in Lower New York. Different.
Really?
Dan. Totally cat. Anybody else on the high school? I find this topic to be one of the most interesting ones. For as much effort as we dove into college athletes, high school is one we have to be probably more concerned about, especially from an age perspective. And Dave, I'll note this, and then Rayleigh, I'll turn over to you. I know you have comments on this. From a personality and maybe just mental, stamina standpoint, I don't think it's a coincidence that we've seen some high-level college football players, and not my words, Rayleigh, you don't have to say anything, but some high-level quarterbacks maybe, again, my words, fold a little bit under the pressure of these NIL deals, be it Spencer Rattler or DJ at Clemson or De'Aaron King at Miami, guys that signed high-level deals and then just kind of dropped out of Heisman contention very, very quickly. So I think you have to worry about that too, especially at a high school level. We don't know what getting that type of money impacts sports. My daughter is walking around in shoes above me, so I apologize. I'll stop talking. Rayleigh, go ahead.
Good. Thanks. Thanks for that too. I think what we're seeing right now is so reminiscent of how we saw the NIL state-by-state landscape playing about a year and a half ago, with states slowly introducing the topic. Right now, Dave, I have to correct you, but I think I misled you with some of my tweets before. I can say as of right now, it is California, New York, and New Jersey. Illinois Ken took a little more digging to find out exactly where they stood, but Nebraska's on the books for addressing this in their board meeting here in the next month. So right now there's kind of three big ones where this is completely an opportunity. New Jersey will be starting here in January, but aside from that, there's three there. There's about 10 that I've spoke with their high school athletic association director who said that they are in discussions for this. There's another 11 whose current amateurism policy needs some clarity. So that's about half the states right now. And I think it'll continue to snowball in a similar effect that we saw. But Dan, I think what you mentioned is very valid, right? In the educational side of it. I come from a background of having a high school teaching degree and previously working at a high school association, and even same goes for higher education. This is a place where student athletes are supposed to receive preparation for their life after sports. So these tax implication kind of situations that Kenneth has brought up, financial literacy, what it looks like to be an entrepreneur, all of these conversations I think are valid. And where I think NIL can have a positive impact is really being a catalyst for those conversations to occur and creating a space that's entertaining for athletes to talk about. That there's nothing more exciting than talking about the Pythagorean theorem at 8 a.m. to high school students, but if you can somehow weave in sports to it, the topic becomes a little more interesting. I think same goes for tax and financial literacy and anything like that. So making this relatable, I think is crucial.
Good luck trying to weave sports into the Pythagorean theorem. I don't know how you would do that, but Rayleigh, you can tell me offline.
Kicking field goals.
Okay.
Dan, I will tell you, however, that yeah, it's moving in the direction. We can see the same issues that affected colleges, and we can see the efforts across the states to address it. What you also are seeing, however, is that people are countering that some of the arguments against high school NIL opportunities are specious, right? Because certainly we've had kids play hockey, tennis, and baseball in their teens. There's no question that we have soccer players leaving the United States to go play in Europe while they're teenagers. And I don't think that we've thought about the gender issues carefully. And as some people have remarked, there are still impacts on the statistically underrepresented groups in the country, right? The persons who really want to take advantage of the opportunities in high school are the ones who are being precluded from taking those opportunities. So yeah, we see some states like California that say, okay, it's okay for high school students to benefit. And we see other states who say no, and other states who say, well, we're leaving it up to the agencies and we need clarity. But the truth of the matter is, I don't think over the next 2 years, the argument against high school NIL opportunities will remain successful. For the same reasons that people thought that the NCAA became a parochial institution that denied opportunities to students. So for example, you'll see arguments made by high school bodies that say education is important, and to burden students with entrepreneurship or working at this point is particularly tedious. But we have some students who are college athletes who help to work on the weekends or after school or after practice to help their moms pay the bills. They're actually working. So to say that we shouldn't burden them with these additional responsibilities is somewhat of a specious argument.
Okay, I think certainly, and Anita, I commend you. You don't have to join in here if you don't want to on this one. I'm keeping track. I keep mental score over here. Anita, I'll lead you off on this one though. So, you know, what I think is interesting, again, that maybe we'll have this conversation. I don't know if we'll have time for it today. You know, so maybe if we end early, we can fit it in. Certainly there's a world 5-10 years, maybe sooner, where student athletes or college athletes are given the right to unionize. And if they are given the right to unionize, certainly that will throw off all the, you know, all college finances. You know, it'll just, everything will be wacky because money will go vertically to particular athletes. It's not going to be spread across all athletic departments. Now, as of today, as of November 15th of 2021, we don't have to worry about that. NIL, for better or for worse, it's only third parties that are paying or giving some type of contribution to athletes. It's not coming directly from the schools. That said, I think it's fair, and I don't really know where everyone stands with this. The question is whether NIL maybe indirectly is pulling money away from schools. So, you know, I think that at least the probably easiest way to phrase it, do you think that NIL sponsorship deals are adversely affecting school and conference revenue as we sit here 100 days in? Are we feeling some type of hit that the schools are getting, or is that maybe unrealized at this point? I'll give it to the floor, or Anita, if you want, whoever wants it.
Yeah, thanks, Dan. I'm not a marketing expert, but what I've been hearing or seeing is I feel like the pressure is more on the donor side of the house than the sponsorship side of the house. I think a university can make a case that what they bring to a sponsorship agreement is very different than the athletes bringing in terms of the return on investment or the value or the target market or demographic that the corporate partner is looking for. I feel that if there's going to be an unknown impact or unintended consequences, is some of these collectives and group licensing ventures that are trying to get donors to funnel money into them to be able to create NIL opportunities that are legitimate and screened and verified, permissible NIL opportunities for the athletes. I think that's going to be where the sort of the rub is, maybe more so than in the sponsorship. But that's just my initial gut feeling. I don't know that we know that for sure, and I suspect Dave has some actual examples that's going on there.
Yeah, so Anita's kind of, in my opinion, there is definitely income that's being left on the table from the use of the marks, right? So I mean, we're seeing here at Syracuse, who's done a fantastic job in certain silos with the student athletes, because they're going to be able to create and charge a royalty because the athlete's going to want the mark there as well, right? So we have a great relationship, student of mine, former student of mine, Hunter Pomerantz, he's with the Players Trunk, and they've done a good job with the Syracuse athletes and using the mark. So that's a royalty, Dan, that they were never going to get in NIL, right? Now let's go to the multimedia rights. Okay, so you have Learfield and JMI are sitting out there, and I'm going to just kind of give you an example. I don't know why this in the last year, but everybody's got like the best chicken sandwich, right? So like I won't even name companies, but let's just use a chicken company here. And you have them spending $150,000 at institution A. And all of a sudden, NIL comes out and they say, wait a minute, the inventory we're buying at a university through Learfield and JMI. So back to Anita's point, Carolina, I mean, it's all public data, but Carolina is going to get $11 million next year for multimedia rights, right? That's including the use of the marks that they can give out to corporate partners. That is all the stadium signage, the internet, everything else in between there, right? So if you're this chicken company that's going to sponsor and you're spending 150 grand, and here's what you get. You get a sign in the Dean Dome, you get football signage, you get men's and women's lacrosse, you get social media, you get all the traditionals. You get a display on the quad, and you get sampling. Okay, but guess what you don't have? You do not have the star quarterback. So you take that 150,000 and you say, hey, Learfield, we're going to cut that back to 100. Institution still gets the 11 million, Learfield gets 100, student athlete gets 50, chicken company thinks we're supporting everybody. Learfield goes timeout. JMI says timeout. We have a contract that's $11 million that we're on the hook for. And now there's nothing we can do to stop this. So I hope everybody kind of understands this is huge. This is, I'm not saying this is why this happened, but Nebraska, and Rayleigh can talk a little bit about this. No more multimedia rights. We're going to bring this in-house and we're going to do this ourselves. And now this whole, right, 10,000 foot view of licensing, multimedia rights, NIL comes under Nebraska. And you don't have these outsourced companies. I don't think that's going to happen. There's too much money there. But Nebraska better be for sure that they can recoup whatever Learfield or JMI was doing at the time and that guarantee. Because right now, Dan, after COVID, everybody wants their guarantees.
Yeah. I'll add just a little bit to it, and I'll kind of steer away from diving too far into where Nebraska stands and everything like that. Just to not speak on behalf of them, but something that I will bring up, and I'm glad you addressed it, Dave, is the situation where this can be beneficial for schools now to have corporate sponsors and revenue coming in from that avenue that they wouldn't have had previously. Taken Isaac's ice cream shop, some random store in town that now is working with an athlete, because an athlete becomes more approachable. The athlete also has a 7% engagement rate on average on social media. You're getting a good audience, you're getting good engagement rate. If they're more approachable than it is to get that in-venue signage or whatever the deal might be, I think that's enticing. So the company, the local business, will be going to the athlete. The athlete will say, okay, let's sweeten the deal a little bit here. Let me put on my game jersey or wear my helmet, whatever it may be. And now they have to approach the school. And so it's almost a three-pronged activity happening here, where the school is licensing their marks, giving their use of marks privileges to the entity who wouldn't have worked with them before. And I think they're starting to engage in a new way here. So I'm happy you brought that up. And I think you're making some valid points there.
Yeah, and Dan, I think what Brady's mentioning here too is, and I know Nebraska's got a really good taco place called like Muchachos or something along those lines. They get a couple athletes that are there. Well, in the past, the multimedia rights holder, right, that might not have been an option. So they're going to spend, I'm making this up. Let's say they're going to spend $1,000, but it would have cost 10 to do anything in Nebraska. They're seeing a little bit of that return on investment. Now they're like, you know what? Not only are we spending with some athletes, maybe we have a little bit extra. Maybe we can spend with the school and the multimedia rights holder, put all of these pieces together. But I know for a fact the multimedia rights holders are a little bit nervous because the athletic department has a guarantee that those contracts are set in stone. Athletes become influencers, right? I mean, in the case of Nebraska with Muchachos, there's two athletes, I think volleyball and football player, that are doing fantastic things. They're not a partner with the multimedia rights holder. They don't have to be, because they're getting that traction through the door. And then the partner, the brand, is supporting Nebraska, but then the multimedia rights holder goes, but that money doesn't come to us and we're on the hook for a guarantee.
I agree with that. And I think as universities start trying to grapple with how much to have in-house, how much to go to continue with their external partners, that is then that sort of that domino effect that's going to trigger some of those Title IX inquiries that Professor Ferguson mentioned and laid out before. Because once the university starts managing directly all of the licensing and multimedia, that's going to bring on a Title IX inquiry in terms of whether male and female athletes are getting equitable access.
It's an absolute excellent point. Excellent point.
Okay, so I think I probably could have asked this earlier because we brought it up a couple times, right? Football and basketball, men's and women's basketball. Those are your three main sports where the money is coming from. I know, Dave, I think the volleyball player you're referencing in Nebraska, and Rayleigh, is it Lexi's son? I think Lexi is the main, right, Rayleigh?
Nick Lynn Haynes was the one specific to Machachos. Yeah.
So, yeah, I mean, there's certainly, I see athletes in particular sports speed. Olivia Dunn at LSU, that'll, she'll pop up on the radars. But by and large, it's football and basketball. So, the question I think the NCAA has to keep track of, maybe it's not the NCAA, right? The NCAA doesn't seem to want any part of this, but how do colleges and universities, how are they incentivized to create equal opportunities for men and women in name, image, and likeness? I know a lot of publicity was given to Bryce Young at Alabama for signing, whether you want to believe it or not, a 7-figure deal with Alabama. But I don't always hear that same messaging, and maybe because those deals aren't out there. But how do you incentivize creating equal opportunities for men and women across the NIL landscape if you're, the AD at a particular college?
Well, I'll jump in first as far as to just confirm the NCAA will not care and will not regulate in this area. They're not subject to Title IX, and they don't want to pretend to be subject to Title IX or even dip their toe in that water. But the universities, that Title IX requirement is the same. It hasn't changed any just because NIL is out there now. So I do think that universities now have a real opportunity to be very proactive to ensure equitable treatment for female athletes, because they can basically define their whole NIL strategy from the ground up with a vision for how do we make sure that whatever programs we create. So let's say hypothetically that we've got, publicity, promotion activities, educational resources, professional development resources, how to build your personal brand, NIL workshops, blah, 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 blah. All of those need to be made available equitably to both male and female athletes. If you're selecting athletes for what formerly was maybe a leadership training program, and now it's going to be more of a personal branding program, there needs to be equitable opportunity. I think universities understand that they have to do that. I just don't think they fully understand yet how that's going to play out. If I were putting a microscope on someone right now, I'd be looking at my sport information department to see, are they messaging consistently when the men sign a big deal is when the women sign a big deal? Our marketing and promotions publicizing not only the athletes and their successes that help to create a higher profile for themselves, and then of course all those life skills and leadership support services. The greatest challenge is still going to be in this group licensing, which Dave talked about, and I think Kenneth has also talked about, is women's sports are already undervalued and underrepresented in our broadcasting agreements, in media opportunities. So that is built into the system. So I do think institutions have to recognize we can't just do the status quo because women are already underrepresented in that space. So to create an equitable landscape, they may have to be much more diligent and purposeful about making sure that female athletes have access to those opportunities and at least the services that they're providing.
And Anita, one of the things that I've tried to keep an eye on is, because I live this world at Sidearm, is the simplistic side of, on a bio, Tori Dilfer, we just did something in class and I absolutely love, she's Louisville, right? Tori's at Louisville, a volleyball player, Trent Dilfer's daughter. What Louisville does in the sports communication side of things, which is fantastic, in her bio, they ask questions of hobbies, and there's a list of things that Tori has. Like, we just ran this in class, and she loves sushi, she loves traveling, she loves to do all these things. Her Instagram, her Twitter, all these things are easily accessible, and for male and female athletes. And as much as sports communication is, hey, the statistics and all this, it's a simple form that the athlete needs to fill out. Because if I'm a brand, and in my class, we're using a program called Sponsor United, and we tasked our students. I picked Tori Dilfer because she's an unbelievable volleyball player, and they were ranked number 2 at the time, and just looked at all of these things on her bio, and they created, by using Sponsor United, brands that should be associated with her. But you can go to hundreds of websites, and it's like, my sophomore year, my junior year. Nobody's reading that. Tell me about Tori. And all you got to do is give her a form. Montana Fouts at Alabama, unbelievable. Her Instagram account, everything that she does there and balances her dog and fishing with her dad and softball and homecoming queen. And she's just, yeah, she's a rock star.
Yeah, and she has a great trademark.
Absolutely.
So she had one of the most creative trademarks when a number of trademarks were announced, and hers was really a fetching image as far as when you're trying to create a great look.
Yeah, and her cousins helped her do that, which is even cooler.
Yeah.
Something I'd like to toss in here, and I actually love to hear Kevin's perspective more on the legal side of this, but one aspect that I think is very important to note here is that the schools are often hamstringed in terms of their ability to promote in the first place. So you take state law, it's maybe more descriptive like Texas or Florida, where the schools are not in a position to be actively promoting online, however you may be, their activities or procuring these opportunities for them. Now, on the inverse of that, you have a state like Utah or Nevada where schools have a lot more freedom to engage in that. But I think the schools, regardless, the schools in those states have been slightly hesitant for Title IX issues, employment-related issues, just in the fact that they might not have the bandwidth to be able to promote and engage in developing these opportunities for all their student athletes anyway. So I think it's the schools in the states with protections around their abilities, around the school's abilities to engage in these NIL promotions and deals. I think they're in a slightly better spot from Title IX just because they can't do it in the first place. So there could be no violation there, but I think that's an interesting thing to unpack.
And Rayleigh, I want to jump in and I want to hear from Kenneth. But from a standpoint of sports information, without saying, here are my interests for NIL, you can certainly fill out, and Kenneth, I want you to jump in, like you can put in like favorite athlete, favorite sport, like hobbies. And what that does is it tells that story for that athlete, and then putting your Instagram and your Twitter, where now the athletic department can say, here's what we're doing, back to Anita's point, for every male and female athlete. If the football player doesn't fill that out and Tori Dilfer does, that's kudos to her, right? But, and I just want to clear that up of not saying like here's, but it does paint a picture of that athlete that you can put on their website.
Yeah, I wanted to just kind of reconcile and juxtapose a couple of things. The first being what Rayleigh said, which is that clearly there are some institutions that are prohibited from lending overt assistance in terms of any kind of promotion for NIL opportunities. Yeah, and then there are others who take a more tacit approach at doing so. But what I share with Professor Moorman is the colleges and the universities have an opportunity from the ground up to actually, with multiple stakeholders in the university, build programs that are equitable. So not providing opportunities or counseling, et cetera, for male students that you're not providing for female students. You have the opportunity definitely to do that. And it would only be wise to do that. So when I mean multiple stakeholders, I mean the AD, I'm talking about the Title IX coordinator, all the persons who have the responsibility for playing parts in gender equity in sports, right? And there are NCAA guidelines on that. So that's an opportunity now to build from the ground up. The other thing is, sure, when you look at a lot of the bios for athletes around the country, they provide the kind of information that Dave just mentioned, right? And so those are ways of promoting male athletes and female athletes that you're actually putting their information out there in the universe for people to see their interests, their hobbies, and so on. But again, doing it equitably. So if we're doing it for the male athletes, we have to certainly do it for the female athletes as well. And to be sure, even now with NIL, there are female student athletes who are doing particularly well, right? They were, what's the name of the sisters?
Cat
Twins.
Yes, right. And then there is the player from Oregon. So
Sedona Prince.
yeah,
yeah.
there's the, I think the track athlete at UM. So long as the opportunities are in fact equitable and the institution is not doing anything that would run afoul of the Title IX rules or but I have another point to make. So even if in fact you're not running afoul of any of those Title IX rules, I think it's particularly important to give in appearance that you're striving for equity in what you're doing with your athletic programs.
Yeah, that's a great point, Kenneth. And, the Title IX regs certainly provide a number of factors, and the the compliance officers should be familiar with that in terms of on that publicity metric for a Title IX audit. But you are looking, for the quality and availability of sports information personnel, access to publicity resources for the men's and women's programs, quantity and quality of publications and promotional devices. So those are sort of the known factors, but it is very possible that the OCR may update some of these factors to provide better guidance specifically in the NIL space. And that would not necessarily be a bad idea once we learn a little bit more about what this looks like, which may start looking at some of those group licensing activities. Just because the intercollegiate athletics has become a much more complex landscape in these last few years.
Okay, so I think I probably we'll see what the next year, 2 years bears out. We have an interesting world of college sports right now. Maybe it's a combination of the COVID pandemic and NIL, but the transfer rules have never been what they are today. So you kind of have two issues that are occurring simultaneously, right? The transfer issue is certainly interesting, right? If a school has a very enticing or very robust NIL department and they're getting these great deals, like I'm sure Rayleigh, you can tell me if I'm wrong, but there was a narrative for a while that Florida schools were getting all these great deals because they were at the forefront of the NIL movement. So we'll see if anybody wants to do the math on the transfer portal, but it was a narrative that guys and gals were moving over to Florida because there was it was greener pastures. So you have two kind of, so you have that on the transfer level. And then you have just the normal level of like just standard recruiting. If the school really has a robust department in NIL, are they really attracting more talent? So I'll open this up. It's kind of two questions, right? How can schools and how are schools using NIL to attract the top transfers and the top 5-star high school players? How is that being done on a school by school basis?
I mean, I'll jump in here if anybody saw the Real Sports segment with BYU. I mean, BYU has put 36 athletes that are getting NIL money that so supposedly has got to go to tuition, right, for Built Bar. And in exchange, those athletes have to do different things. And then each of the 85 scholarship players, and Anita, this goes back to Title IX, right? So now you have 85 scholarship football players that are getting $2,000, and you're getting 36 walk-ons that are getting, up to $12,000 for tuition. So my question here is, what if I'm an athlete that's in the state of Utah or Colorado, and I have an interest to go to Colorado or Utah, and all of a sudden I see that 36, right? Let's say I live in Utah, I'm in-state resident, and if I'm in Utah right now, I'm looking at this going, wait a minute, this is a competitive disadvantage for me because I don't have this donor who's a corporate partner of Learfield and has all of his Built bars all over the place, these protein bars. Now, all of a sudden, from the standpoint of recruiting, the walk-on basically gets a free ride. So I want to know where this is going to go. Like this is, I mean, if you haven't seen this Real Sports 15-minute segment, it's fantastic. It's fantastic. It's Cavender twins. It's got the BYU segment in there. It's JT Daniels. It's really good stuff.
Yeah, I can add a little bit too on this side of it. I think what's so interesting about it is when the NCAA had released their interim policy, one of two core tenets is that NIL activity should not be contingent on enrollment or should not represent a improper recruiting inducement, which, I mean, enforcement staff for the NCAA and compliance folks around the country are kind of putting their hands up, like, how do you define that? How do you determine whether something was a recruiting inducement as opposed to, as opposed to simply just a school offering better resources, right? We see schools across the country who have, like Kenneth mentioned in the speech to start this off, incredible facilities, right? Weight rooms that are better than NFL weight rooms. There's all sorts of resources that are provided to student athletes with the hope that school X looks a little better than school Y. And I think it's no surprise either that you've seen schools partner with companies like Opendorse, other entities in the space around providing education to student athletes. Yes, they want the best experience for student athletes, but I think it's, it doesn't take a super keen eye in the space to realize that a lot of schools are using this as an advantage. I think as a prospective student athlete, weighing this as a serious opportunity to profit off your name, image, likeness is important. That's the number one question trending right now among recruits, is where NIL plays into this process. So I think anyone would be foolish not to bring that up, but I think it's something that's going to continue to develop, and it'll be interesting to see where compliance departments and the NCAA enforcement and others, where all this plays out, I suppose.
I can promise you there's no recruit not asking this question.
I'm sure that is true. And that is also occurring across all sports.
Yes.
It's not just limited to football, men's basketball.
Every recruit is asking the question, and the colleges are intimately aware of the impact on recruiting. And not only that, like I think Rayleigh was intimating to this, the perception of the success of the college is now gone into the decision criterion for the student athlete, right? How supportive is that school with NIL, and how many student athletes there that in fact have NIL opportunities? Students are thinking about those things as they're going through the recruiting process. And then even the thought of with whom would I work and what opportunities could I get? I mean, think about what Deion Sanders said, for example, in terms of attracting kids to his school, HBCU, right? Who better than Primetime to teach you how to be a marketer? I've done it my whole life since FSU, right? Who better than I can support your efforts at NIL? And students, the perception is just as good as the reality. Every recruit is asking that question in every sport.
Dan, can I ask the rest of the panelists a quick question of this example of BYU, where the gentleman from Bill Bar, what he's doing is fantastic, I understand, but the clip in the video is him showing up and handing out checks. I mean, the last I checked, he's handing out checks, and last I checked, the bursar's office does not send you an invoice, right, to him. Like, when they say he's paying for tuition, there's no obligation to take 10, 11, 12. You want a new truck? Go spend 12 grand on the truck. So that's my question for everybody else that I've been perplexed and haven't gotten an answer. Like, the bursar's office isn't involved. There's no way they can be involved with that. Correct? Am I missing something on that end of things? Like, that check goes to Rayleigh, who's a walk-on. He does what he wants with it, even though you're saying it's for tuition to make it look good, correct? And I'm not taking a shot at Bill Barr, because what he's doing, I think, is doing what he can do.
Now, wouldn't that depend on what the NIL laws are saying in that jurisdiction? Because the fact that this institution is doing such a great job in providing those resources to their current athletes, I don't see how that violates any NC2A rules or any other rules, unless there's some kind of an intentional act involved there. Unless, for example, the NIL rules indicate in some statutes say you can't use that money to pay for your scholarship.
Right. So my question, Kenneth, is in the clip, he hands each of those walk-ons a check for up to $12,000. He states that that's being paid for tuition. Is there anything in the state of Utah that says that money, there isn't, correct? That's your name. No, right? Am I correct?
Yeah, I'm assuming so. I'd have to go back and find the statute, but I think that's where you have to start. Yeah. And see what that statute says, because if it says, and some of them do, if it says you can't use this money to pay, your tuition or whatever as a replacement for athletics scholarships, and then that they may run it into afoul of the of the statute itself.
Yeah, I mean, I don't think Utah has enacted legislation yet. There's some pending.
So I guess this I want to make sure we get to as many of the questions as we can. This is probably as good of a transition here if there is any. So on a state by state basis, there was a narrative which, if let's say you're in an Austin Powers frozen chamber for the last 100 days and you're just coming anew now, there was a panic, right? If you were not an NIL state, that you would be left behind. I think that narrative is kind of flipped on its head, Anita, as you just pointed out. In this world, almost it's better to not be a quote unquote NIL state. You have the flexibility to do whatever you want. So to Dave's point, right? You can really, as long as you're not running afoul of state law, you can really do whatever you want, right? Remember, it's not illegal to pay athletes under, federal law or any older state law. These were laws that had to come into play. So what we do have, and I know well, we covered it on our show, but the first college athlete to sign an alcoholic deal was a guy in Florida Atlantic's quarterback, a guy by the name of Nikosi Perry. Florida's NIL law allows athletes to sign deals with alcoholic companies if you're over 21 years of age, which, okay, congrats. I mean, if you can drink, you're over 21 age, fine, that rule makes sense. Meanwhile, over in Pennsylvania, there's no alcoholic deals. There's no carve out in that NIL law and that state law to have that type of deal. So, I think, Dave, this brings us to kind of to your point. You have a state like Utah and a school like BYU, which is very different than our other 49 states, very different than most Division I programs. And, in the Mormon, with the Mormon church being located in Utah, it's a very different sensibility. I know, a lot has been made about their prohibition on deals with companies that are caffeine companies, which you wouldn't see elsewhere. So let me, I guess I'll just, open it up to the floor. What are some state specific issues that you're seeing? And do you see this maybe state by state issue kind of maybe lending itself to federal legislation? I'll open it up. I know it's probably a topic maybe we'll get some resolution on in the coming months, maybe with a federal bill, but I certainly see that it's at least percolating in our legal circles.
Are you thinking, Dan, the state by state issues in terms of types of maybe prohibited transactions, or sort of just their framework for the NIL in general?
Well, I think we can point out, right, that states handling of this, some with NIL laws and some without them, some that have NIL laws and they have them very differently. It's creating another, we'll say another set of potential competitive advantages and another level of recruiting that has nothing to do with playing time, that has nothing to do with your relationship with the coach. It's, something that's we're not really used to seeing in college circles. So I guess I'll open it up. The topic is just generally, differences in states handling, and where we see that going.
Yeah, Dan, I will say.
Go ahead.
Yeah, I mean, I've reviewed the 29 states that have either enacted legislation or have an executive order in place. And there are really similar mechanics at the 30,000 foot level. They all talk about IP, they talk about use of facilities, restricting activities during official team activities, OTA, disclosure, and prohibited activities. But once you get beyond the surface of those mechanics, these bills are all over the place. There is no uniformity among these bills, particularly in the disclosure area, the prohibited activities area, and enforcement is almost non-existent in these bills. Fewer than half of these bills have any language that talk about penalties and enforcement. Same way with policies at the university level. So I've looked at about 32 different NIL policies across all the Power 5 conferences and a spattering of other conferences. So it's pretty dramatic in terms of the variation, but probably in the state bills, I think the restricted activities is probably one of the areas that I've discovered have the most dramatic variation across the 29 states.
And Dan, if I can jump in, the sin categories, right? That's what the term, right? I mean, I am going to be fascinated to see what's going to happen with the gambling side. New York just approved 9 mobile companies that probably go into effect here in February, ironically right around the Super Bowl, where, you had folks that are driving to the George Washington Bridge so they can pick up the location settings in New Jersey to make their Sunday bets, which does happen. So, and now in New York, you can't bet on college sports, or if, Duke and Kentucky played last week in Madison Square Garden. But I'm just curious, some of the sin categories of alcohol and gambling and just what the stances are with some universities. Now, pretty much all of them sell alcohol anyway, but I'd be curious to hear, and I'm sure Braley's got more, Kenneth, on some of this stuff, but I'm just keeping an eye on that. I know that, I think it was MaxBet in Colorado tried to do something with all female athletes, but then I think University of Denver and Colorado each had deals in that category, so their athletes couldn't take advantage because of state law. So there's just so much of that like Anita was talking about.
Yeah, I want to just add into this conversation a little bit around, you're talking about the sin categories. Now, I think an area where there is a lot of flexibility and where certain schools have looked to this to be a more favorable advantage is around their own IP. So the flexibility to let student athletes license marks within their transaction, the ability to use facilities when they host a camp, different things like that. I think those are advantages. While the IP of the institution is something that they hold very close to their chest, I think that's something where certain institutions have found that they've been giving their student athletes an upper hand in their NIL deal. So I think that's worth noting. But a question I would like to pose to the group here, who's all very, very much smarter than I am, is around the jurisdiction that schools have to be able to prohibit competing sponsors. Now, I understand situations where a student athlete contractually is not allowed to wear a Nike arm sleeve while they're an Adidas school competing on game day. But I think an interesting question, and where I think I could see legal implications coming down the road, is around how much jurisdiction does an institution have to tell a student athlete, no, you can't have an NIL deal at any point with one of our competing sponsors, when I personally, don't believe an institution is at a point where they can determine what a student athlete is doing outside of their playing and practice time that they are on notice. Outside of that, the times when they're walking to and from class, when they're out of season, all those different times, I think that's an interesting section that we could see litigation down the road on.
You hit the nail on the head, and I wanted to pose this question to Professor Moorman, actually, because some of the statutes specifically say, for example, that the college student cannot take on an endorsement that conflicts with a contract of the institution, right? It's written into the statute. So therein lies the tension. So the question then becomes, is it in the legislative history when they say you cannot take on an endorsement, is it within what scope? What's the ambit? So if, for example, Duke is a Nike basketball program, could that Duke athlete, could he be required to wear Nike only during game times, but certainly take on a contract to wear another brand at a different time because it doesn't work to disadvantage of the institution at all? I don't know what the answer is. I just know that when you look from state to state, the statutes will say you cannot take on deals that conflict with the regs of your school, and some of the schools have anti-tobacco, anti-gambling, anti-alcohol regs. Some of the actual state statutes say you can't take on contracts that are conflicting with the institution's contract. So I don't know if Anita has seen any case yet in her canvassing of the statutes and the regs, cases in which this actual tension has occurred, and what, if anything, was the resolution to that?
Yeah, I don't think we have any, I guess, recognized conflict or resolution at this point, but you're right. Most of these statutes include some kind of language that either by statute prohibits conflicts or authorizes the university to restrict conflicts by policy. So one of those two avenues is available to almost every university. The problem is they don't define team contract and they don't define what a conflict is.
Right.
And so there's no way to be clear. So what I've seen in the policy piece, not in the legislative piece, but on the policy piece, is universities are casting a really wide net in the way they define official team activities. So they're able to restrict any competing brands or any NIL activities at all during official team activities. And some of the more expansive includes travel, away competitions. And so if you think about you're going on a 3 or 4 day away trip, theoretically, that's a 24/7 restriction. So now if your primary NIL income or revenue is through social media, can you not do anything at all? You know, you're back in your hotel late at night. Can you not say how excited I am to be in Charlotte for this game? Apparently not, according to some policy. So that's how they're getting it. Some of the California universities are listing sponsors by name. And they're just saying, we have Nike, Coke, Powerade, Gatorade, Muscle Milk, IMG, United Airlines. You can't enter into an NIL deal with any brand that's a competitor of those brands. So right now, we don't know, but I think you're absolutely right, Kenneth, that's absolutely where, if litigation is going to happen pretty soon, it's going to be over testing the enforceability of those limits on some of these competing agreements. And Rayleigh may have some examples of some athletes in their system that, you know, really want to push those boundaries, but are running up against those kind of restrictions.
Yeah, I won't give a specific example, but let me just say that if I was still a student athlete and was offered a deal from a competing sponsor of the institution, was told no, might be interested in seeking some litigation there. I don't know. We can maybe take it to court, but I feel like that could be a space where a lawsuit might happen down the road. So
yeah, because the policies don't tell you who gets to decide, you know, and that's where the disclosure piece fits in, because a lot of universities require prior advanced disclosure where they can then assert a conflict. But there's no dispute resolution mechanism for that. So ultimately, that would require court intervention if the parties couldn't agree.
Well, can I jump in?
Professor Ferguson texted that it raises the need for federal legislation. I was going to ask if you would elaborate, if that's okay with you, Dan. I was curious.
About federal legislation?
Yeah, Professor Ferguson just typed that into the.
Yeah, no, I was going to ask it.
Okay.
Dave, did you have a comment before we move on? Because I do have the federal
legislation. I'm more concerned with the marks, because licensing directors are saying, I know that there's schools that are saying, no, you can't use it anywhere. And just by chance, like Anita's at Louisville, they've done a really good job. Like they did a deal with Planet Fitness and the athlete can be in their uniform up on the billboard, right? There's other schools that are saying absolutely not. And again, I'm going to go back to the direction is coming somewhere from every multimedia rights deal in the country includes the use of the marks. So if I use the chicken example and the licensing director gets pressure because there's $11 million guaranteed that says, I can't give the marks, and a corporate partner right, synergy, but I can when it comes to merchandise, because I'm a licensing director and I deal there to make those royalties. There's a huge conflict of interest right now that we haven't even addressed in NIL world when it comes to licensing directors and the multimedia rights companies, because they're afraid to give them those rights. And Rayleigh, I want you to jump in. I mean, your school doesn't have a multimedia rights company. So, and at Louisville, I don't know what they're doing, but the licensing directors obviously having these conversations that we want to promote our athletes, because at the end of the day, right, there is a value to that, but it's all recruiting, folks.
I would ask Anita and Dave too, have you seen or have you fielded this question, which I received? So if the statute says, and if the rule says you cannot wear the logo, insignia, trademark, etc., can I wear an identical colored shirt and style without the logo, without the trademark when I do the photos? Same style, same colors, I'll remove the trademark. Would that run afoul of the statute and or my university's policies? I don't know if you've seen those issues or fielded that question just yet.
No, and my point was, and Kenneth, I'm glad you brought this up. So like South Carolina, I know because of the state, but like in New York, there is nothing. And I'm hearing that states, they have no statutes, are simply saying, nope, absolutely not. And they're scaring the licensing directors to not approve it. And it's coming really, I think, from the corporate partner side, multimedia rights world. So Anita, I'll turn that over to you, because yeah, I'm so Kenneth, that's a great question. And then my question is, with the states that don't, I know Clemson, or I'm sorry, I know South Carolina, you can't. I think that's one of the states.
Yeah, I think South Carolina and Texas are the only ones that actually prohibit at the statutory level, that prohibit their institutions from allowing their student athletes, even if they wanted to, they're prohibited by law from doing that. Now, how Clemson got around that is, if you look at their NIL policy, they acknowledge that you can't use the marks, but you can use the orange, their colors, as long as they don't have any of the official marks on there. So considering how many universities now want to protect their color as trademark or trade dress of some sort, that's getting into a gray area in terms of, if you're permitting athletes to use your trade dress without repercussion, any third party at some point is going to try to push that boundary also. And so you do have to be pretty vigilant to protect. Universities have worked really hard to try to get trademark protection for their color schemes. I don't know that many of them have strong trademark protection, but they certainly would say they do. And so now they're wandering into that territory of how do we let our athletes, when we can't use our IP. But as a practical matter, it really only affects South Carolina and Texas, I think. Most of the other universities are kind of all over the barnyard in terms of how, I guess, permissive or welcoming they are to that co-branding relationship. Louisville is really in the middle of the spectrum, even though we have this Planet Fitness thing with Malik. That's only because Planet Fitness is already an official corporate sponsor with U of L. So a non-official sponsor would not be able, so technically Malik Cunningham does not have the right to use those marks. Planet Fitness has the right to use those marks while having Malik featured in their advertising. So it's kind of a little in between.
Right, but Anita, there are, in that case, it's that chicken sponsor, because that Malik's getting that money, and there are schools that are denying that because they're taking that pot away from their budgets, right? And that's where Louisville's done a really good job to say, you know what, they're a corporate partner, because Planet Fitness next year could say, fine, we're not going to renew for $100 grand. We'll go spend all the money. So you guys can see where this is like that teeter-totter back and forth with all of that. But yeah, I give kudos to Louisville for doing
sure.
Let me jump in quick, guys. So it's 7:30. I know Christian earlier had said, and I think the panel maybe will go a little bit, see how many questions we get. If you do have questions, feel free to drop them in the chat, and I will I'll do my best to feed them to our panelists. So the question that Professor Ferguson had written in our panelist chat, a little behind baseball, guys. You know, we got a prompting from Professor Ferguson because and we were a little bit keying to it. You have conflicts across different states. You have conflicts with respect to who can and can't use intellectual property, when you can't use it, right? So the example that I give my students in my sports law class, when you go to any state in our country and you go to a bar, you know how old you need to be to have a beer. It's 21 years of age, right? It's pretty simple. It's a clean rule. Maybe it's not the best rule. Maybe I can make an argument that it's better if the rule was 18 or if it was 19 or 25. But there is some value to having consistency across state lines, especially in the world of college sports. You wouldn't want someone to get a recruiting edge just because someone's politician is, very savvy, right? You wouldn't want that to be the rule. Same deal over, I know a lot was made, we didn't bring him up, but Quinn Ewers, the top high school quarterback in the country, was at Texas, was supposed to play Texas high school football. And because of the NIL rules, decided that he wasn't going to play high school football. He was just going to sit out a year and start collecting NIL deals a year early. So I'll tee this to the panel. And at least from my vantage point, I think there was a world where all the schools, wanted some type of federal legislation. In advance of July 1st, we had 2 congressional hearings in June for a federal bill. And now 100 days in, personally, I don't think there's the same fever pitch from the schools to get a federal bill. Dave, you made a point earlier, right? How is Utah allowed to do this, right? And Built Bar, and this guy's giving so much money to the school. How are they allowed to do this? Well, to Anita's point, right? Absent some type of state law, who's going to go in and yell at BYU? Unless BYU wants to yell at themselves and raise their hand. So I'll turn it over to the floor. And you guys all have different connections to colleges, to athletes, to particular sports. What is the word? Is there a sense that a federal bill is wanted? I have some indication of whether or not it's likely, but do people want a federal bill still as we sit here November 15th? I'll open that up to everybody.
Yeah, I'll start and be quick on this one, Dan. I think there is an interest from the schools in the states that feel disadvantaged. That's not any shock there, but I think the schools in the states that feel as though they have an advantage, why advocate for national standard? If anything, that would curtail a lot of the work that they're already doing and a lot of the freedoms that they do have. So I don't necessarily see the same advocacy that we had originally seen, just because we're seeing half of the states, maybe even a quarter of the states interested in this federal legislation. I also will say, I think the reason that we saw a lot of competition die in DC, there was a lot of issues at hand that Congress needed to address, but for NIL specific, I think the devil was in the details, in that certain situations like healthcare for athletes started to get weaved into the mix. And I think the more variables that you added to the conversation around NIL, the more cumbersome it gets to pass legislation. So that's my 2 cents there.
It's interesting in that there does appear to still be genuine interest in having some sort of either federal or uniform approach to NIL, but the devil's in the details, right? So I think the NCAA wants some antitrust protection, right? I think Rayleigh makes a great point. The states and schools that got out in front of this and sort of, staked their claim in this space aren't in any hurry to have everybody else get caught up. I do think there will be some sort of a uniform solution. We obviously now we do have a Uniform State Act that is available for adoption. And so the National Commission of Uniform Laws has approved a template, a model, and that's been a common approach to solve a lot of these cross-border issues. It worked for athlete agents. And so what happened there, the states, of course, adopted, the Uniform Athlete Agent Act, but you did have the federal government come in and put SPARTA on top of that. And so for those states that didn't adopt that Uniform Act, there was at least some, basic protections. But that was more of a statute built around protecting athletes from, deception or abuse or misrepresentation. This is more of creating opportunity and removing barriers to opportunities, which I think are more complex. So while I think a federal solution or a national solution is needed, I'm not convinced that it is forthcoming.
I don't think it is forthcoming either. It's not on the immediate horizon, I don't think. And where I think that there's clearly bipartisan support for the NIL efforts, I think there's some other things that need to be addressed. So you were right about the way the agency acts evolved across the states for protections. But with NIL also comes some responsibilities, right? And so the federal government has an opportunity to speak to those responsibilities. So for example, you talked about disclosure. What disclosures would a student athlete have under FTC regulations if, for example, he is a stock owner or his father owns stock in a particular corporation with whom he's done an endorsement? What are the implications for international students who are here on a granting aid, but are popular enough in their homeland or wherever they are, such that a company wants to do business with them here in the United States? What does that mean in terms of regulations? What does that mean in terms of visa requirements, taxing, et cetera? So there are so many other issues in terms of the responsibilities that then fall on the programs or on the students that eventually we're going to have to speak to those issues. And I don't hear the fervor that we had heard at the beginning of the year now. And of course, those who are being advantaged don't want to necessarily upset the apple cart, but nonetheless, you can see where we're going to spill over into some issues, tangential issues that the federal government itself has to deal with. I mean, it's only the federal government that can address immigration status, right? I mean, not the states or the taxing status. So, well, federal income taxes, I mean. So there are places that the federal government and things that they will need to speak to, just not yet. I think they're trying to figure out how not to seem to act in the antithesis of this movement towards empowering athletes, and don't know yet how to craft legislation.
So, Professor Lewis, my sense, and I think everyone's on the same page. I think if you put betting odds on whether there would be federal legislation on, we'll say June 30th, I think you'd got a number with a minus in front. I think people felt pretty confident that would happen, and not anymore. I just don't hear people going up and down and banging for it. And what are the states that are getting these big advantages? Florida is very big in it, all of SEC country to some extent. So those are, they say the SEC has the most power in all of college sports. And, I think we're seeing that a little bit on the legislative level as well. I think if SEC schools really wanted it, I think you'd hear more of a push for it, but you're not. So we haven't gotten any questions from the crowd. I want to make sure we hit this. We did hit, actually, let me hand it to you, Dave, before I give you my last question. Dave, you mentioned a point that I know I mentioned on social media that I know a lot of people were curious about. Spencer Rattler coming into this past season was one of these Heisman hopefuls. He was at least on some lists, not unanimously, but was supposed to be the number one quarterback taken in the NFL draft. This guy that signed a lot of deals, multiple trucks. You keep talking about the chicken company. I think the company you're referring to is Raising Cane's, but signed a deal with Spencer Rattler.
There's a bunch of them, Dan.
They all have the best chicken. They all have the best.
Yeah, they all have the best chicken. They all claim that.
So, but Spencer Rattler signed all of these deals, and then he's benched. Obviously, he came back this past weekend and played a little bit. But what is let's say we're out here and let's say we have some businesses that are listening to this this event, and you're a business that signed up with Spencer Rattler, and you're paying the guy a ton of money or driving around whatever cars, you're giving him a lot of compensation, and the guy is riding the bench. What do you think is there to be done for a business, if anything? And I know you mentioned Cam Newton, the guy that was out of the NFL, and then all of a sudden he's back in a high profile spot. So I'll give the floor to you about this issue that I think, to Rayleigh's point, it hasn't been challenged yet, but I imagine a business will at some point try to get out from under one of these type of deals. It just makes too much sense.
Well, Dan, you can't stop posting. They're going in a shell, some of these athletes that aren't playing, and they've stopped posting. So how can I create some engagement? And they're afraid of comments, right? So he stopped. I mean, he was just religious on, you know, till this last week, we've been laughing in class going, every week we come in, they're still undefeated. They're still undefeated. They're still undefeated. And then there's an opportunity. What if Caleb gets hurt? What if this transpires? And sure enough, you know, I'm watching the game this weekend and here he comes into the game, right? Or he's getting the chance. We want Spencer. We want Spencer. So from a brand standpoint, there's got to be a clear cut engagement activation plan that he's going to keep posting. I mean, we have Josh Allen that's 2.5 hours down the road, and now he's got all these great deals. But at the first couple of years, he had deals, wasn't playing that great, right? So I think from the brand side of things, I mean, you got to keep going. I mean, we have thousands of athletes across all platforms that have sponsorship deals that run into this at some time where they're not performing, right? I mean, if you're a brand, you better be understanding of what you're getting into with an 18 to 20-year-old kid. I mean, that's, you know, I mean, I'm more concerned, or I had a little bit more concern was the athlete who signed a deal and then that weekend got a DUI, right? So Spencer stopped posting. Like, you got to continue on Twitter and Instagram, even though you're going through a rut, because the brand, there's an obligation there. And you know, the biggest thing is, I walked into class one day and a student said to me, Professor Meluni, did you see what Spencer Rattler did? No, he removed OU from his Instagram and his Twitter. And I'm like, how did you know that? And they're like, I don't know, some guy in his basement's following him and he tweeted it out there, right? I mean, as much as we're joking, and all of a sudden, Dan, it was back. It was back within a matter of minutes. Somebody screenshot it. Everybody speculated he's going in the portal. You know, this kid has had a lot of hype since he's been on a Netflix series called QB1, and it's back to your point. It's a lot of pressure. It's the #1 recruit in the high school, #1 quarterback in the country, or #1 quarterback in the country, and you know, his backup at high school ended up going to Michigan till you know, he had some medical stuff. But to answer your question, the brand's got to be out there. How are we going to activate? When are we going to activate? No matter what happens. What if an athlete tears their ACL? Right? They're not playing either. So.
And I'll give you one further, right? Let's say you sign a local deal with, with someone, with an advertiser within the state, and there's no term on that deal. It's just kind of indefinite until you're no longer a pro. And let's say you transfer to out of state, you go to Florida.
Yep.
What are you supposed to do then, right? So I think the general rules are that you're not allowed to take deals away based on athletic performance. But different question, in law, is separated from sports. We have something called frustration of purpose is one of the many types of ways to get to at least try to get out of a contract. Or, if there's like Macy's Day Parade and like there's just winter storms, right? We have force majeure, just something that should and sometimes does cancel a contract. If you sign a local deal with an Oklahoma-based, a local bar, maybe not bar, but a restaurant, and the athlete's no longer there, right? Spencer Rattler transfers to, some random school, Florida State. Is that local Oklahoma business still bound by it? As of right now, you'd hear, experts say yes, but the question is, should they be? So I think it's another fair question.
You raised an issue that I was hoping that we'd get to, because we've often taken a look at NIL from the athlete's perspective, right? But what about the business's perspective? And so now you're touching on an issue that I wanted to touch on, because realistically, why would you not have the duration of the contract, no matter how big the company is? Why would you not have the morality clause in the contract, no matter how large or small the company is? Why would you not have those specific terms in the contract? So it's one thing when you go approach the car dealer and say, would you do this deal? Or the local juice manufacturer in the city to say, would you do this deal with this student? But realistically, we have to think about the fact that those things need to be in the contract on the front end to begin with, right? And that avoids the litigation that you're talking about on the back end, because what's the obligation of the company to pay? And to be sure, all the statutes, all the college guidelines, all the conference guidelines prohibit paying for performance. So what you're going to describe and delineate in the contract is not payment for yards and touchdowns and whether you've run sub 10 in the NCAA track and field final, because you can't. That's not what you're paying him for. You're paying him for NIL. But nonetheless, the contract needs to be artfully worded to address the relationship and avoid the kinds of issues that we can see occur on the back end.
Excellent point, Kenneth.
Okay, so it's 7:45. We just got so many questions from the audience. No, I'm just totally kidding. We didn't get any, which is, you still could drop them in the chat if you want to. So there's a comment, and while we have time, I want to make sure everyone gets their parting thoughts in. Rayleigh, I'm gonna start with you because I know you have some comments on this. I want to hear your kind of closing thoughts on NIL, and then if you can pivot forward. Obviously, we have a lot of law students in the chat, and the reason this event is so heavily attended is because people might want to get into this space. So maybe I'll go across the panel, but your parting thoughts on NIL, and then maybe some advice to people that are looking to get into the space. You all have unique backgrounds, so any insight you could provide would be appreciated. Rayleigh, we'll start with you.
Yeah, absolutely. So I think in terms of parting thoughts, Kenneth's last comments are interesting to me around contract structuring, the duration of contracts, morality clause, all these different aspects, I think, play into generally the education that needs to be continually developed around NIL. And I understand that out of our audience here, it'd be a needle in a haystack to actually have a student athlete probably listening to this. But regardless, I think those who are tuned in and listening now have an impact either on a university, as a professor, as an FAR, whatever it is. They have an opportunity to be able to positively reinforce education around NIL. So that preparedness, that financial literacy, every touch point that goes into one of these deals is not only a temporary skill that it's going to provide, $30 as a quick social media post to them, but these are skills that can be developed for the rest of a lifetime. So I want to get that out there as a parting thought. And now to the question from the audience for what this could mean for a law student interested in the space. I think a great place to start is certainly where you're at. So your institution that you're at right now, get in touch with the compliance office. Those are the boots on the ground perspective, reading the disclosures submitted and getting connected to see what NIL opportunities are happening among the student athletes at the school, and really hearing those common pieces of feedback that schools are experiencing. So I would not discredit that at all. And I'd really encourage that you get connected with your compliance office to just, again, shed some light on what's happening where you're at.
Professor Lewis, I'm going to give it to you next. Twofold. So part one is your parting thoughts on NIL, and then part two is advice to students trying to get into the space.
Okay, thoughts on NIL? These opportunities, I think, were long overdue. I think it's a good thing that we're allowing college students to benefit from their name, image, and likeness. Certainly, we had allowed the NCAA to do it from the athletes' name, image, and likeness, and it seems parochial is the euphemism I'm going to use, and counterintuitive. So I'm glad that we're in this space. Certainly, we are not even 2 years in, so we're continuing to learn. And in as much as the athletes themselves are curious, the institutions are curious and the lawmakers are curious. So there's a lot that will unfold in the months to come. I also want to see things grow for high school students. So we have, for example, the kid from Tampa, Arian Knighton, right? Who broke Usain Bolt's U20 record as a high school athlete, but it's not considered a high school athlete. It's considered a world U20 record because he left high school to take advantage of becoming pro. I mean, what would happen, for example, if we allow high school students and those who particularly need the financial help and revenue to take advantage of NIL issues? What would I recommend about getting involved in this space? I would echo a lot of Rayleigh's comments, but I would also say to attend symposia like this, to get involved in the grassroots efforts for the various organizations that sponsor these types of things, to reach out to the local universities and the bar associations. And there are a lot of international groups, quite frankly, who are sponsoring these kinds of symposia. So learning and making those relationships particularly helpful way of getting involved and learning more about the space.
Okay, so I see two questions from the crowd, which I think are touching on the same points. Anita and Dave, just from scheduling purposes, I'll leave it to you guys to answer this. But the questions from Evelyn Kaup and Omid Shamim. So Evelyn asks, can anyone speak to what schools are doing for students, educating them on the implications of these contracts and the income that comes in? And Omid, I think, asked a similar question. How do we ensure that parents, coaches, and institutions have the students, athletes' best interest in mind as to their own? And I think it speaks to this question, and there's a great 30 for 30 out there called Broke, which is about professional athletes at an incredibly high rate, going broke right early on. So the question is, how do we educate our student athletes? So what is being done on that front for education? I think I'm going to use my spider sense over here. Dave, I feel like that's a question for you over at Syracuse. If you want to take the education question, and then I'll tee you up on your final thoughts. But go ahead and if you can answer that for our audience.
Yeah, I mean, from the educational standpoint, I'm teaching a course, but that's the monetization, the name, image, and likeness. But really hits the nail on the head. It's going to come back to compliance, and I think each institution, and this might tie into Dan, the other question for the law students is, how do you get involved? Because you have to understand, a compliance officer, nobody's been prepared for this wild west, and I would sort of guess that most of the compliance officers don't have a background in law. They really don't, right? I mean, they somehow got in, they might have been a student athlete, they were working in another capacity. So there is a lot of opportunity for law students, in my opinion, at all different institutions. From the education standpoint, yeah, I mean, we just had this conversation. I had it the other day with a gentleman in my office that's trying to work with Syracuse on the financial planning side, specifically now because of NIL, right? And educating parents on the tax laws and things like that. My class is more focused on touching upon the law, but all of the things that you can do to monetize the name, image, and likeness, dealing with journalists and things like that. So I'm sure Anita has more on that side of things too.
Go ahead, Professor Moorman.
Great. One thing I wanted to point out is that I was going to kind of open this question, as far as what are schools doing for students. Certainly in-house, it is falling on compliance right now. But if I looked in, if I tried to forecast the future, I don't see this being in compliance much longer. I think it's too big for compliance. I think we're going to see, just like we've seen learning specialists evolve into their standalone section within academic services. I think we're going to see NIL mentorship as a standalone division in Division I programs, so in large programs. Obviously, that's going to trickle down differently into smaller schools with fewer resources. But I think you do have to have people who aren't just compliance lens focused people. They have to understand contracts. It'd be great to have legal background, but you also have to understand the licensing, marketing, and personal branding and social media. And that is that's a mixed bag of skills that are needed. In terms of on the ground, where I don't know if we're ready for the sort of the big picture throwaway, Dan, or not, but my concern,
by all means,
my concern going forward is opportunities for athletes that are not the premier athlete that are already on ESPN's top 10 watch list or something like that, whether they're smaller sports, whether they're community college athletes, NAIA, there are opportunities out there. And so I think for those athletes, they're not going to be able to hire a marketing agent. So they really are going to be dependent upon resources that are available through the school or resources that are available through some sort of a third-party provider that does that. So I'm hoping to see that as the next thing. Right now, we're seeing these third-party providers partner with schools to develop educational program. I'm really hoping that eventually these third-party providers actually just have standalone educational platforms that any student from high school all the way up can log in and watch a module about this or that or the other. And they already have great content out there, and it is generally available for everyone. And so I think that's where the schools have to go. For law students wanting to get into this business, like I said, there are going to be NIL departments in every Division I athletic program within a year. So you can get in there. Our law school actually has a clinical program, an NIL clinic. So we have third-year law students who do advise student athletes that can't afford an attorney or that don't have an agent. And we can advise them in terms of consulting on an agency agreement, in terms of the agents presented them with a contract and they're not sure whether it's appropriate. And we can also advise them on an NIL deal. Not every school is going to have a law school, and not every law school is going to have a clinical program that can do that. But to the extent that you are someplace where your law school has a clinical program, that may be something that you go and talk to your dean about. Is this something that we can do? And then you can get some hands-on experience before you go out there and either go into representing athletes in these deals, working for marketing agencies, or either working in college athletics.
Okay, so we are getting close to 8. I don't see any other questions from the crowd. I think everyone got their floor in with their big picture stuff. Our panelists have anything else to add before we close this?
Dan, I have one just quick thing moving forward. I'm going to go on the brand side. We haven't even hit the Super Bowl. And what I mean by that is we haven't got to the College Cup from a brand standpoint. We haven't got to the Women's College World Series. We haven't got the March Madness. We haven't got the bowl games. That is a huge part of what we're watching, right? When you get to a Final Four for men's and women's soccer, you get to March Madness, you get to a college football bowl. There are athletes right now, I guarantee you on the football side, that are nervous if they don't get the 6 wins, because that's another 5 or 6 weeks that now they could possibly monetize and even work with a bowl game to promote ticket sales and do all these different things. So if I'm a brand right now, I'm looking at these athletes, who's going to make a bowl that maybe I could do, because, you know, and even like the Montana Fouts of the world, if she makes that World Series, I'm looking at that. So everybody's Super Bowl, we haven't had one yet in college sports. So let's just keep an eye on the bowls and March Madness and championships.
Okay, so I think, Dave, those were some good words just looking ahead. I think that'll put this panel in the books. Chris, I don't know if you want to have any final words, but this was lovely. Thank you all for attending. And yeah, if you want to reach out to any of us, I'm sure Chris and Amanda have our information. Chris, did you want to add anything to officially put the pin on this?
No, I just wanted to thank you guys so much. You guys really did crush it. It was a super compelling conversation. I think a lot of people are going to take a lot out of this. So just thank you to the panelists and Dan. You guys did a fantastic job.
Okay, well, thank you,
Thank
everyone.
you, Chris.
Thank you very much for the invitation. I enjoyed meeting and speaking with everyone.
Thank you, everyone. Have a lovely rest of your Monday evening. And again, thank you very much for attending the Albany Law Symposium. Excellent job. And thank you again, panelists.
Thanks, everyone.
Thank you, Christian. Bye-bye.